Hello, my name is Robert Walker, accountant and insolvency practitioner. This is the 7th in my series on managing insolvency in troubled times. And in this session I'm going to address the history of compromise and some of the problems that arise briefly. Now, our current compromise regime in the Companies Act of 1999 can be traced back to the Joint Stock Company Arrangement Act of 1870. There's quite significant differences between what was available in the 19th century compared to now. Back in those days, compromises could only be given effect by liquidators, and they had to apply to the court to do it. Now, the purpose of doing it was not to save the company as the compromise regime is now, but to rather preserve the business by taking it out of the insolvent company and putting it into either a new company or an existing company. The example that best illustrates it is the insurance business. Insurance is still a complex business with difficult liabilities to calculate, so they can sometimes get it wrong, and they did in those days. And what would happen is that the policyholders en masse would be picked up out of the failed company, transferred to a new company with the assets following in their wake, and their rights would be abated accordingly. So you can see it's preserving the insurance business. Now, the New Zealand regime is different to that because it happens outside liquidation. In other words, it is for the purpose of saving the business, or the company along with the business, saving them both together, in other words. And that's its real, that is what makes it a gem. Now, at that point, what I will do is not reinvent the wheel, and I'll refer you to a case I've mentioned before, which is the definitive case in New Zealand on compromise, and I suspect on the globe for compromise. And that is the Bank of Tokyo and Solid Energy, the reference you can see on the page displayed. Now, Justice Winkelman, for reasons of analysis to demonstrate the points that she comes to, the conclusions she comes to, refers to the history back to the 1980s. And what happened is the report prepared by the Law Commission, published in 1989, that led up to the Companies Act of 1993, lamented the underutilisation of the compromise regime, and they ascribed that lack of utilisation to the need to apply to court to have a compromise proposal approved. They thought that the dead weight of legal deliberation killed it, and I'm not disagreeing with them. And indeed, the Companies Act of 1993 made that quite radical step of taking compromise out of the court and put it to where it belongs, which is into the hands of the creditors who have much but not complete powers, as we've discussed, because of the cram down. No need for a court. Indeed, I think that the Bank of Tokyo case illustrates why you would not want courts to be involved. It's a 69-page judgment, there are all sorts of issues raised. Some of them I think are frivolously raised or based on sophistry, and fortunately Justice Winkelman, applying a practicality that I think does her reputation a great deal of good, dismisses each one of the objections to enable, I think, the compromise regime to survive. Now, one of the issues that we did discuss before that she saved was the ability to swap debt for equity. We've also discussed how she considered the matter of solvency and had a practical interpretation of that particular issue. And she also deals with the issue of classes, and you'll see that is the brooding presence that lies across the compromise regime as we move into the practicalities of implementing it. I think, to be fair, the Bank of Tokyo illustrates the problems as to why you would want to avoid the dead weight of the law. The necessity for demonstrating things beyond just common sense is such in a court that it requires vast amounts of money. No court action would enable a compromise to be effective for small to medium-sized companies, might be for very large ones, and we are talking in solid energy about a very large case. Okay, so perhaps justify going to court, but you can see it would get very, very expensive to try and contest these ideas. I say, and I'll repeat this, that if a director who's a proponent approaches the compromise with transparency and honesty, small peccadillos will be overlooked, I am sure. Now, the story doesn't end there, because the Law Commission back in the 1980s was probably right about the impediment to utilisation of the compromise regime, but the Law Commission considered the matter again, and this time wrote a report in 2001. And they had a different reason for why it still was not being utilised. What is that? Nearly 20 years later. And I will quote what they said in their report, which is Insolvency Law Reform, Promoting Trust and Confidence. And you can find that on the Law Commission's website. And they said, Parts 14 and 15 of the Companies Act were grossly underutilised. An educational issue was raised in relation to some creditors, that is, they tended to focus on the benefits to shareholders or directors from the use of those procedures rather than on the potential benefit to the creditor by way of distribution if the economic value of the business was preserved. An educational issue was also raised with regard to the managers of insolvent companies. What it's essentially saying is two things. That creditors, they thought, are sceptical, and that is why nobody proposed to use compromise, and they're also saying that people are unaware of it. Now, I think that the first part of that's unduly cynical. I think that the real problem isn't that creditors are sceptical of it. I think the real reason is that people just don't know about it, hence what I am trying to do now is to promote it. What you will find is that if you approach it fairly as a director, that creditors, once they're told that they're not going to get all their money, they're annoyed. But they also are practical, and they sit down and say to themselves, 1 cent is better than no cents. 10 cents, of course, is better than 1 cent, and so on. So they generally agree to it, unless you've been dishonest in some way. In other words, education is the key to this. Now, I think the real reason, or the other reason that it wasn't used and it had fallen into disuse, is because it does have this brooding presence of the definition of classes. You'll see that it needs to balance up the rights of creditors, so it divides them into classes, and we'll talk about that in a session too. And those classes are quite difficult to determine, so I'll have to devote a significant proportion of time to determining how you determine what classes are. Fortunately, the Bank of Tokyo case does deal with it, so it sets out a way forward to the extent there wasn't one already. So I think it's important that the Bank of Tokyo case has taken place. We can thank the astute intellect and practical inclination of Justice Winkleman, as she was, for essentially setting out the issues with respect to compromise, which, if you are familiar with the issues that can arise, you can make the matter of compromise work. So that's where we now stand. It's been changed so it's outside the scope of liquidation, it's an alternative, and importantly, it does not need a court involvement. It can be there, but it's not necessary. Please, if you wish for written material, look below the video and you will find ways to acquire it. Thank you very much. Bye.